And I know that you're all going to be very sad to part ways with me after today. Don't worry, I'll miss you just as much, but I know that you'll make the most of it. Today, we're going to start with application proceedings. And I want to tell you that we have basically finished the program that I was supposed to do with you this week. We finished that last night already. And now I'm going to deal with what, according to your program, is the self-study in red. That's how nice I am. I'm going to assist you now with what you are supposed to do in your self-study. I'm going to try and do as much as possible of that today. And we'll see. We might even finish everything. All right. Before we commence, do we have any questions? Break the ice. Going once. Going twice. Gone. Okay, thank you. We shall then proceed with today's program. And I want to start off with applications. The last few days we've dealt with actions, summons proceedings. And today we are going to deal with applications, which are the other alternative to action proceedings. So I remember we said that you have a choice whether to go the action route or the application route. And the criteria you will use to decide whether to go action or application is whether you anticipate that there is going to be a material dispute of fact. And if there is going to be, or you anticipate that there is going to be a material dispute of fact, you go the action route by issuing summons. If you do not anticipate that there's going to be a dispute of fact, the best route to follow is the application route. But bear in mind, there are certain proceedings that may only be instituted by way of summons. A divorce, for instance, may not be instituted by way of application proceedings. The Divorce Act specifies that you may only institute divorce proceedings by way of an action. So there you don't even have to look at whether you anticipate any material dispute of facts. You have to go by way of summons. If you want to sequestrate someone or liquidate their estate, you have to do that by way of application only in terms of the rules. The legislation tells you can only do that. But in most cases, also in terms of urgent applications, if you want urgent relief from the court, and that is mainly by way of interdicts, you may only do so by way of application. There is no such thing as an urgent summons. There's no such thing as an urgent summons. You've heard of an urgent application, and you will only hear of an urgent application. You will never hear of an urgent action. Hopefully not in my lifetime, but we never know. Our law is so dynamic and it changes all the time. Something might just happen any day that we're alive. So be on the lookout always as to when you may follow the application proceedings, or you have to follow the action proceedings. Now, you'll see that on the chat, I typed out some keywords which are important for the differentiation between action and application proceedings. I've already told you that action proceedings are initiated by way of a summons and particulars of claim, whereas application proceedings are instituted or initiated by way of a notice of motion and a founding affidavit. So your summons is the equivalent of your notice of motion, and your particulars of claim are analogous of your founding affidavit. If you have to compare the two, this is to make it easier for you to understand. And they contain the same things, except because the facts that make out your cause of action, the founding affidavit and the particulars of claim. The only difference is that the one is an affidavit and the one is a pleading. In the affidavit, you will use, in the first person, I am the applicant. I am making this affidavit in support of the application for the relief that I want. In the particulars of claim, you say the plaintiff is Joe Soap. The defendant is John Rope. But something that's similar to them is in the summons, you'll say the above honorable court is vested with the necessary jurisdiction to hear this matter. In the founding affidavit, you will say, I submit that the above honorable court possesses the necessary jurisdiction to entertain this application. Then you start with the facts. So there are similarities because they are essentially the same thing, except that the one is an action and the one is an application. And when you in an action, you respond to a summons and particulars of claim by filing a plea. In an application, you respond by filing an answering affidavit. Now, in response to the plea, you file a replication in an action, whereas in an application, you file a replying affidavit to the answering affidavit. Action proceedings are heard in what is called a trial court, whereas application proceedings are heard in motion court. In a trial court, the parties will have to lead oral evidence in support of their cases, whereas in motion court, the legal representative for the parties will stand up in court and address the court on the papers, on the affidavits. The affidavits, take note, an affidavit is a sacred document. It is deposed to and commissioned under oath. It is deposed to and commissioned under oath by a commissioner of oaths, which attaches some sort of
for tomorrow morning. Woo! But everything is okay. Also, my mic is on. Let me switch off.
Can we please all ensure that our microphones are muted? Can we please all ensure that our microphones are muted? Thank you. In an action, after the hearing of oral evidence by the respective witnesses, the legal representatives of the parties both have to do closing arguments. This is where they argue the facts in their favor, the law in their favor, and they ask the court for the relief as prayed for in their respective pleadings. In an affidavit, I beg your pardon, in application proceedings, the parties are required to file heads of argument in support of their cases. It's a requirement. The rules require it, the magistrates' court's rules. Also, the directives of the various magistrates' court's rules also require that you file heads of argument. And without heads of argument, your case will not be given a date. That's the rule. At least one party must have filed heads of argument Some divisions, some districts or regions require you to file a practice note in addition to your heads of argument to just limit or narrow the issues for the magistrate to see. So that in a nutshell is the difference between an action and an application. I cannot teach you about applications without having done that analogy for you. And it's also to make it easier for you to understand as at a very basic level. So going forward, these notes that I posted up there for you, these keywords should, I hope, make sense to you now and assist you when you are trying to prepare for your exams or study or try to remember the difference between an action and an application. Adam Sibia, can you please repeat what you just said? I just heard network issue. Whoa, Adam, which part? I said so much.
No, I got it, Advocate. Thanks.
You got it, eh?
Yeah, thanks.
Thanks, Adam. Thanks. I'm glad you got it, my brother. Thanks. Right. Which applications may be brought by application? There are a number of cases that may be brought only by application in terms of the Act. That's the Magistrates Court Act number 32 of 1944, as well as the rules regulating the conduct of civil matters in the Magistrates Courts. There are two main categories of applications. The first one is an application for substantive relief. Word substantive should tell you that it deals with substance, volume. So that is where you ask the court for something specific. In other words, you initiate proceedings by way of that application. It's called a substantive application, or it is called the main application. Whilst that application is proceeding, and in application proceedings, there are only three sets of affidavits. The first one is the founding affidavit, followed by the answering affidavit, and followed by the replying affidavit. You may not file any other affidavits other than these three affidavits in terms of the rules. However, should new facts come to light after the replying affidavit has been filed, and it only became, the party only became aware of this evidence or information after the replying affidavit had already been filed, the party desiring to file a further affidavit in response thereto may bring an application to court to file a further affidavit. In fact, must bring an application to court to file a further affidavit. That application brought by that party will then be called an interlocutory application. Interlocutory meaning inside proceedings that are already underway. Interlocutory or interim, if you like. That is what is referred to as interlocutory. Another example of an interlocutory application is in an action. When there's already an action underway, the parties have filed pleadings, and for some reason, one of the parties has failed to file a discovery affidavit after having been served with a Rule 23(1) notice, and having failed to file their affidavit, and having filed an affidavit, I beg your pardon, and having failed to file an affidavit within 20 days. Then the party that wishes to that has served the notice wishes to bring an application to compel that party to file their discovery affidavit. That application is called an interlocutory application as well, because it is inside, or it is whilst the main action is pending. So interlocutory applications are applications that are brought, for the lack of a better word, piggybacking on an already existing application or action. Okay, so those are the two different types of applications that you get. You also get what is called, Richard, I hope you're listening, an ex parte application. An ex parte application is an application in which there is no respondent. It's relief that is sought, and I'm going to have to venture outside of the magistrate's court's rules now for this example, and make an example of an admission application. If you want to be admitted, or rather, when you have done your articles and you want to be admitted as an attorney, you will have to apply to court. You have to apply to the court to admit you as an attorney, even as an advocate. And because there is no respondent, it's not an adversarial proceeding. If, for lack of a better explanation, it's a friendly application for relief, either a declaratory relief to declare you a fit and proper person, and to admit you, to give you leave to be admitted as an attorney or an advocate. So that is an ex parte, an example of an ex parte application. And you have to follow the provisions of Rule 10 when you bring an application ex parte. In some urgent applications, where it would defeat the purpose of the relief sought to have to serve the papers on the respondent or respondents, the court may grant an urgent court order ex parte. In other words, without you having to serve the papers on the respondents. You'll notice in your notes there is reference to many court cases. You are to familiarize yourself with those cases. Those cases are the leading cases in terms of those legal principles. And let me give you a tip about cases, using case law in favor of your case. And I see many a practitioner make the mistake of lumping 10 cases into a document in support of one legal principle. Even 3 cases in respect of a legal principle are a lot. There is only ever one leading case or a locus classicus on a particular legal principle. And those books that I referred you to a few days ago, Aimless Precedents of Pleadings and Van Blerk's Precedents, Pleadings, those books tell you everything. The leading cases are in there on every legal principle. And to this day, I use Aimless Precedents to draft heads of arguments. It just makes everything so simple. You need not go far if you are in possession of a copy of Aimless, but make sure at all times that you have the most updated version, because the updated version will have the most recent cases. So if you're using an old publication, you may be referring to the wrong cases because they may have been either overturned on appeal, or they may have been taken to the Constitutional Court. Right. I spoke to you also about amendments of pleas. Now, if you want to amend a plea from an admission to a denial, you'll have to do it by way of application. Yes, sir. Question.
Good evening, Council. Apologies for joining so late. It's been a bit of a hellish day. Just regards to the ex parte application, on your draft order, I just want to get clarity on this. I've had cases where magistrates and judges are requested and cases where they don't. There is a specific clause in your draft your draft order that is called an anticipation clause. I just want to know whether that is a requirement on each and every single ex parte application that you bring, that an anticipation clause is included.
It's not compulsory at all. The party who will seek to anticipate should know the provisions of the rules and should know what to anticipate. I don't see any prejudice to any party if you don't put it in an order. However, some magistrates and some judges may be quite picky about it, especially about the type of relief that is sought. And I think it's warranted in those cases where people's rights will be affected adversely. And in most cases, they probably are. So it's rather best to err on the side of caution and include it in your order without the magistrate having to ask you for it, or the judge.
Thank you, Council.
Pleasure, sir. When does one file a supplementary affidavit? Thank you, Sandra, for telling Agnes when you may file a supplementary affidavit and how you may file a supplementary affidavit only on application. You may not just file one out of the blue. You have to bring an application to court to file it, and you must tell the court that you've received new documents or new information after the filing of the replying affidavit. But you cannot just file a supplementary affidavit out of the blue. You have to bring an application to court on notice to your opponent as to why you want to file a supplementary affidavit. Right. I missed the names of the books, colleagues. Please write it here. Someone assisted Palesa. Yes, Cora, thank you. Aimless Precedents of Pleadings. The other one is called Van Blerk. I just can't remember the publication. Someone had written it the other day. Aha, now some people are being caught out because the books were mentioned and written down the other day. Mahlatse wants to know what happens in an instance whereby a defendant lies in their responding affidavit and later on changes their statements. Can their first response then be used against them by the applicant in court? Okay, Mahlatse, we don't call it a responding affidavit, okay? We call it either a founding affidavit, answering affidavit, replying affidavit, or a supplementary or confirmatory affidavit. Okay, first of all. Secondly, how do you know when, and when you are talking about affidavits and applications, you don't refer to a defendant, it will be a respondent, okay? But let's say one of the parties in an affidavit lies. How do you know they are lying? If you have evidence or proof that they are lying, you disclose that. And as we all know, with one of our ministers or past ministers, if you lie in an affidavit, you may be found guilty of perjury. And perjury carries a criminal sanction. So be careful not to lie on affidavit. Okay? I'm not suggesting that you must lie somewhere else, but just don't lie at all, right? If you tell the truth always, then you will always be free. Ex parte application without noticing the other party versus audi alteram partem. I don't understand that question. I suggest you wait for me to rather continue with what I'm saying. You might just get the answer there. In an application, main application or an interlocutory application, the applicant must serve the notice of motion and founding affidavit on the respondent, just like the plaintiff must do on the defendant in an action. How is the person going to know that they have a case to answer? So service is essential, not just in urgent applications, but in all applications where notice is required. And that is in order for the person who is being sued, because by way of application, just like an action, you are still suing someone. You want relief from them or against them. You want it from the court against them. So you need to know who's unknown user. Okay. So you need, it's essential that you serve the other side with your papers. The sheriff, practically this is how it works. You consult with your client. You decide you're going to go the application route. You draft a notice of motion and a founding affidavit. And after having drafted the notice of motion and founding affidavit, your client has commissioned the affidavit. You have signed the notice of motion and attached it to the founding affidavit with annexures. You then make sufficient copies, depending on how many respondents you have. There will be a copy for the court, a copy for you, a copy for the respondent. But always make an extra copy because papers go missing. When you go then physically to the registrar's office in the jurisdictions where we do it physically. But in other bigger jurisdictions like Johannesburg, Pretoria, Cape Town, they make use of case lines where you can issue your papers online. But some of us are not as advanced and we are still on the ground here. So physically what you do is you go to the registrar with your original and your copies. You tell them you want to issue these papers. The registrar issues your papers by giving you a case number. It is a numerical number which follows the previous one of the case that was issued. So they issue you with a number, a case number, and they put a stamp on each page of the documents. And the reason they put a stamp on each copy of the page of the documents is because after having issued papers, some practitioners change the pages of what is contained in there. So if the registrar puts the stamp on each page, you cannot change any pages after that. You then, after having been issued with your papers, go to the sheriff's office. You give the sheriff the original, because when they serve those papers on the respondent or respondents, they must display the original. And they must explain to the respondent what is contained in the notice of motion. The applicant has gone to court and wants the court to give them an order against you for the following. And according to what is contained in the founding affidavit, you have done this, you've done that, and you've done that. And This is why they've gone to court. If you want to oppose this application, you may do so, but you've got 10 days within which to do it. Then you've got another 10 days within which to file your answering affidavit. You must respond by way of an answering affidavit. If you cannot do these things on your own, you may go and speak to an attorney to assist you. An attorney will charge you a fee, though, so prepare yourself for that. And then the sheriff will ask the person, do you understand what I've just explained to you? And if it is the respondent, one of the respondents, or both respondents, or all respondents, they will either say yes, they understand, or no, they don't. If they don't, the sheriff will try and simplify it so that they understand. Then the sheriff will do what is called a return of service and send it to that attorney and to the court to say, this is how I handled this process. This is how I served the papers or did not serve the papers on the respondents and the reasons why they could not serve them. A person may not be served with any legal proceedings if they are under the age of 16. So they must be 16 and over to be served. And the significance of that is because the actual respondent, who may be a major person or an adult, may not be at the residence or the address at which the sheriff is going to serve the papers. There may be a helper or a child. And if that child is under the age of 16, the sheriff may not serve that child with any legal proceedings, summons or applications. That, sir, I hope answers your Audi alteram partem question. Who drafts the notice that accompanies the notice of motion and founding affidavit? The notice of motion is the actual notice, Mr. Mankope Malebie. That is the notice you are referring to. The attorney will sign that notice. Okay? Or the applicant himself or herself. If they are representing themselves, they may also sign that notice. What then when the client just found out that there is a judgment in his name and was never served? Judgment of what? An action? An application? We're referring to applications here now. What when the client just found out that there's a judgment? I don't understand the question. Was never served. If they were never served with the papers that led to the judgment, then that person may bring an application for rescission of that judgment on the basis that they were never served with the papers. But provided that they also have a bona fide defense. The sheriff or attorney, Mr. Mankope Malebia, you answered your question. The attorney, sir, not the sheriff. Okay. Candidate attorneys may not sign notices or pleadings. Usually the attorney does the drafting using the facts obtained during consultation. Tolagele, what is that? Yes, using the facts obtained during consultation. That's correct. Ms. Malebia. Okay, thank you. Which cases need personal service? Preferably all cases need personal service, but it is compulsory in cases of contempt of court that the actual person whom you are seeking to have committed for contempt of court is served personally. Without personal service, you will not get an order for contempt of court, right? But preferably in all other proceedings, it is the first prize to get personal service, more especially where the rights of that person are directly affected. Basic rights such as housing and so on, dignity, equality, the ones in Section 2 of the Constitution. In those cases, the courts will insist that there's actually actual personal service on the persons concerned. Summons dropped at the door where there is no person in the house to sign for it are legally binding. Okay. Mafemana, we are not dealing with actions anymore. Summons relate to actions. Okay. But for your sake and for your benefit, I'm going to bring you to our applications. If the sheriff gets to your door and you are not there and they want to serve you with papers, but they must have made several attempts to try and serve you personally. If they get to the door and the door is locked, or the gate even is locked, they may affix the application papers to the gate or to the outer principal door. The gate is satisfactory, especially if you have vicious dogs on the other side of the gate that prevent the sheriff from getting in. But we all know that you can't enter someone's premises without their permission, especially if they are not there. And jumping over a gate or a fence is trespassing. So the sheriff will not trespass to serve papers, especially if it's clear that there are no persons behind the fence and behind the doors. So affixing of those papers to the gate, to the principal outer door of the house, are acceptable ways of service of summons, but as a last resort. As well as cases that fall within the ambit of the National Credit Act. Yes, you have to have personal service in those cases. Janus, thanks for that. Nontobeko, your hand must be tired by now.
Thank you so much, Advocate. And I might be just taking us back a few steps. I just needed to understand how important is it to identify for the sheriff when they're giving out the return, for them to fully identify who the person that they served was in the instance that they did not do a personal service. So for them to not just say it was a person who appeared to be 16 years and older and in control of maybe the office space and whatnot, but is it really important that they also identify them by name and their actual position where they found them?
Yes, that's a very important question. And yes, the answer is yes, yes, yes. They have to identify the person. They may ask for identification. In fact, they actually should ask for identification so they can correctly describe the person. I've seen returns of service where the sheriff says that they served the document on Mercy, the receptionist. And then when the answering papers are filed, they say, we don't have a person by the name of Mercy who was a receptionist. And they use it as an excuse not to file. So it's important for the sheriff to verify that person's identity by asking them to identify themselves, by either showing an identity document or some other identification document.
Okay, thank you very much, Advocate.
Pleasure. Right, now we're going to take a few steps back now. We're already at the sheriff's office and my battery is low. I have load shedding here now at the moment. It's supposed to have come back at 6. And it hasn't come back yet. So if my laptop goes off, please bear with me. I'll try to get back in. If I'll try to get back in as soon as possible. There we go. Good evening once again. I apologize. As I was explaining to you about my electricity troubles, my load shedding troubles, my computer went off. It's still not back on because there seems to be a problem here with the electricity for now. But I'll continue on my phone for now and see how far I can get. I hope you can all hear me.
Loud and clear.
Yes, we can.
Yes, we can, Advocate.
Thank you. All right, we'll see how far we can get so long. Eskom really doesn't make life easy for us. I apologize for that. While I hook up here. Right. Where were we? Right, now I've told you that we've already been to the sheriff, already been to the registrar, but we need to step back now before we go there. I arrived there because I wanted to show you that I was answering one of your questions, make you understand how it's done practically. Now, your client comes to you, consults with you, and tells you all the facts relevant for the application. Now, a few days ago, I told you that your clients will vent. They will use this session to vent. Let them vent. Let them spill their guts, as the Americans say. Let them talk. You are supposed to provide them with some sort of comfort, some sort of relief, even if it is you don't have a case or you don't have a defense. But rather, listen to them until they finished what they wanted to say, and then you give them well-considered advice, like the expert attorney or lawyer that you are. Now you sit and you listen to your client. They will give you facts. They will tell you a lot of things that are not relevant. It's up to you with your critical mind to establish which of those facts are relevant. So you now, from the facts that you've been given, must distill the relevant facts for your cause of action. Because they will form the foundation of your application. You will set out your facts similarly to the way you would in your particulars of claim. In your founding affidavit, you will set out those facts as elaborately as possible. Remember, your affidavit in your motion proceedings or applications is your actual evidence. It's not going to be supplemented by way of oral evidence. No, it's not going to happen. So you need to make sure that you put everything that is relevant in there factually. You cannot, the other party is not going, you cannot assume that the respondent is going to know what you are trying to say by not saying something in your papers. You have to say everything in your affidavit to make sure that you've covered all your bases. Because if one simple fact is omitted from your answering affidavit to complete your cause of action, then you are up the street, up the creek without a paddle. You cannot fix it. And in terms of the rules relating to motion court proceedings, you have to say everything relevant to your cause of action in your founding affidavit. You cannot come now in your replying affidavit and want to tidy up your facts to complete your cause of action. No, no, no. The courts are very strict about that. And it's up to you also, as the respondent's attorney, to pick that up when the applicant tries to sneak in facts that were supposed to have been put into the founding affidavit. It's important that you keep an eye out for that. So you put all the facts in your affidavit relevant for the cause of action, as well as asking the court for the relief, the legal principles that you are relying on, the law in your favor. You will be required to state the law only with precision, only in your heads of argument when the matter now goes to the opposed court to be argued. So you need to know when to do it. It is, I will not say it is correct to, oh, there I am back again. I will not say that it's incorrect to put it in there, but the appropriate place to put your law is in your heads of argument. Unless you are stating a pertinent or relevant legal principle, you may not refer to case law in your affidavits. And an example of a legal principle is Plascon-Evans rule. If you want to mention the Plascon-Evans rule, and this is at this stage, you want to do so in your replying affidavit, because the respondent in their answering affidavit have not disputed or denied any of the facts in your answer in your founding affidavit. Then you say, in terms of the Plascon-Evans rule, there is no dispute of fact, there are no denials, and as a result, the court must find in your favor. That's just an example. It's not exactly what the Plascon-Evans rule says, but it's just an example of when you may refer to a case or a judgment in your affidavit. Thank you, Cora. I'll get a Mac with my next upgrade, and I can charge it with the power bank. Mahlatse, maybe we should call it a week. Oh, sorry. I wish I could. I also want to go home, believe me. But there's work to be done. We're almost there. Don't worry. I won't keep you for too long. Can we mention case law in our application for proceedings? Heaven, have I answered you in any way? Thank you, Heaven. Right now, I said already that your affidavits are like your pleadings in the action. So the same factual allegations have to be made to complete your cause of action. And that refers to the description of the parties. It refers to the jurisdiction, the facts that you rely upon, except in an affidavit, you will put more rather than less, because that is your evidence and you want to get it all out there. You will then, in your affidavit also said, your founding affidavit say that based on the facts, based on the legal principles and the law, you submit that you have made out a cause of action, and the court must grant you the relief as prayed. Notice there we are praying again, not in church, but the relief we want, we pray for. Then as I said earlier on, oh yes, annexures. Annexures are very important. Annexures refer to your documentary evidence that you rely on. For instance, if you say in your factual evidence, in your facts, in your affidavit, founding affidavit, I wrote a letter to the respondent on the 12th of June to ask him to keep his dog behind a locked gate, and he refused to do so. I annex here to a copy of the letter that I wrote to him and mark it as A. He cannot dispute that the letter was written. He may say he wrote the letter, but he didn't give me the letter. The letter never got to me. So all sorts of scenarios can play off here. You just have to make sure that when you say you wrote a letter, attach the letter. And then you say, as proof thereof, I asked him to sign my copy, and here's the signed copy that he signed. That's his signature there on the date and at this time. Unrefuted evidence. If you rely on a contract, you must, and it's a written contract, you must attach that contract to your founding affidavit in support of the allegation that you are making now under oath. The respondent, after having been served with the application now, the notice of motion and the founding affidavit by the sheriff. Let's say you are the respondent, the actual respondent. You look at these papers, because you are not a legal person, you decide, and because you have the means, you decide you are going to enlist the services of an attorney, a firm of attorneys. You call the attorney's firm and you want to make an appointment. The person on the other side is your secretary or your receptionist, whom you have trained to ask the relevant questions. What is your inquiry about? Would you like to speak to one of our attorneys? All right, what type of matter is it? Is the civil matter? Is the criminal matter? Oh, a civil matter, okay. Or they will probably say, I don't know, it's just, I received this notice of motion from the sheriff today with something called a founding affidavit, and I don't know what's going on. Sir, just calm down, please. Can you read the notice of motion for me? What does it say? Take notice that the applicant intends to make application on this date, at this time, for an order in the following terms. 1, that I be interdicted. 2, that I return, blah, 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 or I do something. Then you will say, all right, fine. I think the best attorney in our firm that you need to speak to is Mr. Heaven, because Mr. Heaven specializes in civil litigation. I will make an appointment for you. Are you able to, what is that date again on the notice of motion when the case will be heard? It will be heard on the 12th of August. All right, fine. There is still time, but I suggest as quick as possible that you come and see our Mr. Heaven so we can assist you. We have an opening tomorrow afternoon at 3 o'clock. Would that suit you? Yes, that's fine. In the meantime, are you able to scan and email the documents through to our office so that we can look into the matter in the meantime? There, you know what type of matter it is. You know that your firm does the case, those types of cases, and who the person in the firm is designated to do that type of work. So the client comes in now on Friday at 3 o'clock for the consultation with Mr. Heaven. And hopefully you won't tell them to go to hell. Right? They come in, they consult with you, and you listen to their story. Once again, as I said at the beginning, you do not interrupt your client when they tell you. You'll say, okay, fine. This is a notice of motion, it's a founding affidavit. You explain, you simplify it for the client. What is the relief that they are seeking against them? And what are the facts that support it? Now you ask your client, do you have a defense to this application? And if they say yes, you ask them, what is that defense? And you listen to their factual side of the story. Again, without any interruptions. Let your client tell their story to you. Let them tell you what happened and how it happened, when it happened, and why it happened. So those questions are important that you ask your client when you consult. What happened? When did it happen? Where did it happen? Why did it happen? Those are the questions. And always ask why, until you are satisfied. And when your client has now given you the factual version of what happened, you must now, as their representative, tell them that whether they have a defense or not, and guide them in the right direction. You should know what the law says about it. You should know if the law is in their favor or not. And if it is not in their favor, you should be bold enough to tell them and why, so that they understand in a language that is simple and straightforward, so they understand what exactly you are trying to tell them. And if they do have a bona fide defense, you say, all right, fine. I've now got your version. I'm going to do a bit of research on the law as well to supplement our answering affidavit. You may go away now. My secretary will call you when I'm done with the answering affidavit for you, so we can go through it again, just to make sure I've captured everything correctly. Fine. Thank you so much. Goodbye. Then you get to work on that affidavit. You draft the answering affidavit, and when you are done, and while you consult with your client to get their version, you ask them if they have any evidence, factual evidence. I beg your pardon, evidence, documentary evidence to support any of their allegations that they are making, because the facts as they give to you are allegations until they are proven. If they say they do, ask them to bring those documents. But when you've got everything now, then you start drafting the answering affidavit. In your answering affidavit, now I'm going to stop there first and jump to what is called our action proceedings. And in our action proceedings, what you can also do, in addition to pleading, you may also plead specially to any of the allegations in the particulars of claim. It's called a special plea. And a special plea is a plea, it's a legal point on an aspect in the action that can be raised, that can dispose of the action without the court looking at the merits of the case. Now, let me make an example. For instance, jurisdiction or the lack of jurisdiction. The plaintiff could have gone to the wrong magistrate's court. Instead of going to Benoni, they went to Boksburg Magistrates Court. And you, as the defendant, because you live in Benoni, you raise a special plea that no, plaintiff went to the wrong court. And as a result, the action must be dismissed with costs. Jurisdiction is not sufficient. Lack of jurisdiction is not sufficient for a case to be dismissed. It may be struck off the roll because it's in the wrong court. It may not be dismissed for lack of jurisdiction. Other special pleas, for instance, prescription. If you raise a special plea of prescription that the plaintiff's claim is prescribed, and you succeed with that claim, the court may dismiss that claim with costs. There are other special pleas which may be raised, and they are lis pendens. The case, a similar case with the same principles, is pending before another forum, either in the as an arbitration, a mediation, or somewhere else, but not in the same court. And as a result, this case must be dismissed for lack of, because of that. Then another one is arbitration. Now, especially in construction law cases, you have these agreements, construction agreements between the parties. And almost certainly in every single one of those contracts, there is an arbitrations clause that says before any of the parties can go to court for relief, they must, not they shall or they may, they must subject the dispute to arbitration. There, the court may dismiss that case because of that. Or the parties may agree to park that case until the arbitration has been heard. Now, in a similar way, in an application, a respondent may raise a special plea, but it's not called a special plea. It's called a point in limine. A plea in limine. You may raise the exact same legal points as I've just mentioned in an action, in an application as well. So you may raise jurisdiction. You may say you're in the wrong court. You may raise lis pendens. The application is being heard somewhere else. You may raise prescription, if prescription applies. So you need to know when and how to raise a legal point in those cases. Okay, I'm going to check your questions now. Hello, bottomless pit. Okay. Nape. Answering affidavit and notice of intention to defend. How do they follow each other, or is the answering affidavit attached to the notice of intention to defend? No. Answering affidavit is attached to the notice of intention to oppose. In an application, we don't defend. We do that in an action. We defend in an action. We oppose in an application. All right? Oppose in an application. But you'll find that the notice to oppose is required to be filed first. That tells the applicant of the respondent's intention to oppose the application. The answering affidavit is required to be filed after another 10 days only. So the answering affidavit will be accompanied by a filing notice or a notice of filing. An affidavit cannot just be filed willy-nilly like a pleading. It must be accompanied by a notice of filing. This is subsequent to your notice of motion. So your founding affidavit does not have to be filed with a notice of filing. It's already attached to a notice of motion. Your answering affidavit will be attached, must be attached to a notice of filing. Your replying affidavit must be attached to a notice of filing. Otherwise, you will be seen as having defaced that affidavit by letting parties write on it that they've received it. You need to file a notice of filing with it. Caroline Nomahlubi has a question. Special plea. Is it plea in abatement? Who wants to take that question, please? Who would like to answer that question? Special plea, is it a plea in abatement?
Counsel, if I may venture into what I
Caroline,
believe
may
might
I
be the
ask you
answer.
where you came across the word abatement? The term? Okay.
Counsel, apologies. If I may
Caroline
ask,
is not there. So has anyone heard the phrase plea in abatement?
apologies, Counsel, can you hear me?
Cora? Yadis?
Yes, Counsel, can you hear me?
I'll be honest with you, I have not come across it.
Sorry,
Veronica?
Counsel. Isn't she maybe referring to the
Who wants to
debate
take this question for Caroline? Special
Yeah.
plea, is it plea in abatement? Okay, we will all check it up and we'll come back to you, Caroline, okay? For
Sorry,
today's
Donald.
purposes, let's proceed with what is relevant for now, but we will get back to you. In application proceedings, there is no notice to offend, but rather a notice to oppose, and then the answering affidavit follows within the prescribed time. Thank you, Mandy, for that. Unknown user, notice of intention to defend is usually filed for an application for application proceedings. It's usually called notice to oppose or notice of intention to intention to oppose. Okay. Is the class still on? Can't hear nothing. Yes, Mapula, we're here. We are still on. That's at 6:45. Tolagela says, I'm in action proceedings. Okay, you've corrected yourself there. Yes, it is. We are dealing with motion with application proceedings now. Maybe log in again. Yes, it is. Okay, yes, log in again. Page, please, guys. My connection kicked me out. Okay, I hope you found the page. Page 117 of the study guide. Leslie, can you please elaborate on the Plaskon-Evans principle when the court considers an answering affidavit? I knew this was coming. I knew this was coming. It seems as if you can't hear Ali and Yanis. Someone is talking. I don't think Advocate can hear us. Not sure if Advocate can hear us. I don't think you can hear Janus or Ali. It seems you cannot hear the colleagues asking questions. Can Advocate hear us? Apologies, counsel. Seems that our voices are not coming through. I don't think the Advocate can. I saw it somewhere. Think Advocate, I'll wait. I'll wait. People are answering, but you do not seem to be hearing them. That's true. I don't hear anyone. Can somebody say something, please?
Advocate.
Hello. Hello, can you hear me?
Something.
Hello.
I really can't
Hello, can you hear us?
We can,
hear. I wonder what
we
happened.
hear each other.
Let me go out and come back in again.
Okay, let him log back in.
Hello? Yes. Can you hear me now?
Yes, sir, we can hear you. Can
Can you hear us?
I can hear somebody. I heard two people talking now.
Okay, perfect.
Great.
Okay, great. It means it's working. Sorry about that. I was not aware that I couldn't hear you. I just thought that maybe you accept everything I say. Okay. In all fairness, Cora, I'm going to go to Plaskon-Evans. Plaskon-Evans, but I just want to quickly check something. A good lawyer knows where to find the law. Plaskon-Evans rule. That rule will humble you. Ask some judges. The Plaskon-Evans rule is when factual disputes arise, relief should be granted only if the facts, as stated by the respondent, together with the admitted facts in the applicant's affidavit, justify the order. You get that? So in other words, in short, if the respondent has not denied any facts in the founding affidavit, then, and the relief is not far-fetched, it's supported by the facts, which are not disputed by the respondent, then that order should be granted. That order is justified. Does it make sense, Cora?
Yes, Advocate, but I just wanted to rephrase my thinking of it, and maybe I'm wrong, but that the court will adjudicate a matter based on the respondent's version in an application unless the respondent's version is so far-fetched that it cannot be believed.
Yes, far-fetched or untenable.
Yeah.
Yeah, that's correct. That's exactly what it says. You're right, the respondent and not the applicant. My apology.
Thank you, Advocate Pitt.
My pleasure, ma'am. Okay, I can hear you now. Voices are coming through. I saw it somewhere. Thank you. People are answering. Okay, where we now? Let's see. Special pleas are separated into dilatory pleas and pleas of abatement. Okay, that's not a question. I don't think. Okay, dilatory pleas, please delay the cause of action, whereas pleas of abatement destroy the cause of action. Can I ask you, colleagues, learned friends, my learned friends, do not bother yourselves with terminology, right? Worry about things such as plea in abatement, claim in reconvention at another stage, all right? For now, we just want you to learn the basics, right? The basics. You are still going to do articles in a firm, and you have got the right to ask your principal, what does this mean? Give them a hard time, because if you do not ask questions, they will assume that you know everything. And there's not ever anything such as a stupid question. If you go into your articles and this profession with an open mind, willing to learn at every occasion, believe me, I said this before, the sky will not be the limit will be the sky. I've noticed in this profession, and I've been doing this since 1997. I've been teaching law since 1997. And I've noticed how lawyers subscribe to a tendency of complacency and mediocrity. I'm sure there is someone out there who should inspire you. Someone not far away from you, someone from the same town as you, someone who went to the same university as you, someone who's from the same village as you, who is now a judge in the High Court, the Supreme Court of Appeal, the Constitutional Court, or any of those positions that require hard work, dedication, and excellence. What is stopping you from wanting to achieve excellence? Yourself. It can only be yourself. You cannot blame other people for blocking you. If you want to achieve greatness, you will get it despite your obstacles and hurdles. So shake off that notion of mediocrity. Strive for excellence, strive for greatness. And I promise you, this profession will reward you. Not necessarily in money. Money is not the first thing on our minds here. Your first objective when you receive an instruction from a client is to give that client the best possible service that they could get from anybody else. You must remember that you are in competition with other lawyers. And the mere fact that that client came to you should tell you a lot, should motivate you to want to put in the best possible effort. You don't want that client coming back and saying to you, I should have gone to SIPO next door because I'm not happy with your 51% effort. 51% was what we put in at university to pass. Some of us aimed for distinctions. Some of us aimed for 100%. Here is the place where you aim for 100%. This is the place where you put in 100% effort, because you want a client who is 100% happy with the outcome. You want a client who is going to pay you 100% of the fees that you've charged them. And as a last resort and as a last bonus, you will get paid for it. And if you strive for excellence and greatness and satisfaction of your client first, believe you me, money will come to you. Money as the bonus will come to you. But I want to tell you something else. The ultimate prize in this profession is not filling your pockets with as much money as possible. It is how long you can remain in practice. Longevity is key. Many attorneys get struck off the roll, get suspended from practice because of wrongdoings. They didn't adhere to the 100% rule. 100% yes, in their own selfish favors and dishonest favors, but you don't want to go down that route. So I implore you, let's make this profession honorable again, as it was in the beginning. And Bob Marley would probably say, so shall it be in the end. But I know we can all do it. And I trust and I have faith in all of you that the reason why you registered for this course is because you want to aspire to that greatness. And you can and you will do it if you put your minds to it. All right, before you clap hands, let's go on to the next one now. I think I've made the point in terms of applications. Now, what type of causes of action can you bring applications in? We've spoken about an application to compel discovery, an application to amend pleadings. Now, there was a question earlier on. What do you do if a judgment was delivered against you or obtained against you and the papers were not served on you? And there, as I said earlier on, you can bring an application to rescind that judgment. Rescind or set aside or cancel the judgment. It's very quiet here. Are there still people here? Can someone say something, please?
Donovan.
Something, please.
Yes, we are here.
We're still here.
Thank you. It's good to hear you're still here. I was worried for a moment there. An application for rescission of that judgment. Now, an application for rescission of the judgment is, now remember, there's already a judgment in the action, or even let's say the application, either way. You now need to bring an application, an interlocutory application to rescind that judgment. Interlocutory, that's the word. Is the chat not working? Whose microphone is on? Please mute. Thank you. Okay, so you bring an application, an interlocutory application to rescind the judgment. On notice to the party who obtained the judgment against you.
Sibongile, your mic is on.
Sibongile, mute.
No, wait, we want to hear what they are discussing there first. It was rather funny. Okay. On notice, and it's an interlocutory application. You have to serve it on that party. In the application, you will have to start afresh, say who the parties are, say why the court has jurisdiction. And in this case, the jurisdiction will be founded on the fact that the judgment was obtained and the main proceedings were instituted out of the same court. So the court has automatic jurisdiction. You then say what the application is about. It's for the rescission of the judgment delivered on this date. And here's a copy of it, Annex A. Then you give the facts, blah, 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 blah. Then you make your own submissions and you say you were not served with the papers. Although there's a sheriff's return of service that says you were served with the summons, you did not receive the summons. Or maybe raise something such as the address on the return of service is not my address or where I live. I do not know the person who was served with the summons, and therefore I dispute that I received service of the papers. In a case like that, the party who obtained the judgment may even consent to rescission of the judgment so that the parties can hear the main case. All right, that's an example of a rescission application. And if that rescission application becomes opposed by the other party, there will be an answering affidavit and a replying affidavit, and the matter will go to the opposed court. The opposed court will now decide whether that application should be rescinded or not, that judgment. That is an example of a rescission application. An application for summary judgment is also an interlocutory application, but summary judgments are different to ordinary judgments. If a party brings an application for summary judgment, and we said a party may do so
Simpiwe.
Okay, we are going to take a 15-minute break now. I think people are tired. Let's meet back here at 7:15, please. Thank you.
Thank you, advocates. Thank you.
the bathtub and the shower and the toilet is gonna be by the window. We're thinking that we're gonna make this window a little small.
Okay, I'm back. And hopefully so are you.
Yes, we are.
We are back.
I know that it's been a long week for all of us. Can I please ask that just two things? Because it's as I said to you on the first day, it's quite disruptive if somebody's mic is on, because it interrupts my train of thought or chain of thought. And I have to wait for that noise to subside or go away before I can continue with what it was that I was doing. It's not a very difficult thing. Please, guys, let's try to do that. Secondly, and probably more importantly, can I ask that all the questions you ask from now on, if you have to ask questions, be confined to application proceedings only. Please. Otherwise, we are not going to make progress. We are not going to finish what we had planned to do here. And I don't see us finishing anyway at the rate we are going. Another application is an application for joinder. Somebody's mic is on. Can you please mute your microphone? Thank you. An application for joinder, where proceedings have started and the applicant realizes, or even the plaintiff or the defendant in an application realizes that there's a party that has not been joined to these proceedings. That party will then bring an application for joinder of that party to the proceedings. You cannot merely join a person without an application. You have to bring an application on notice to the other party. That is also an interlocutory application because there are already existing proceedings in place. I think by now you have a pretty good idea of what applications are about and what interlocutory applications are about. When the parties have filed all the affidavits, the notice of motion with the founding affidavit, the answering affidavit, the replying affidavit, both sides file their heads of argument. They then go before the magistrate who's going to hear the case. The applicant will stand up first and address the court. The applicant will tell the court what its case is, argue their case. Sometimes you don't even argue your case. The magistrate and judges do this in the High Court. Even in the Supreme Court of Appeal and in the Constitutional Court, you will notice that the legal practitioners are asked questions by the judges, the magistrate in this case. The magistrate will ask you questions. I had a case which was not a winnable case, and I knew that. My client was the respondent, was facing an application for eviction by the landlord. My client was running a supermarket in the office of the landlord. By the effluxion of time, the contract, the lease agreement had expired. So it was a month-to-month contract. So the terms and conditions were still the original lease, although it had expired. The terms and conditions had been the same. The landlord then gave the tenant notice to vacate. In terms of the lease agreement, it was done in that way because the terms and conditions of the lease still applied. My client said that the contract had been extended verbally by an official representing the landlord, which official was nobody. The official was no longer employed by the landlord. So there was no proof to begin with. But when we went to argue the case and the applicant's legal representative wanted to stand up and argue the case, the judge said, no, you sit down. Let's hear what Mr. Pitt has to say. I said, yes, my lord, what would you like to hear me on? The judge said to me, here we have a written lease agreement between the parties. Your client's defense is that the contract was amended, the lease agreement was amended or changed by a verbal, was replaced by a verbal contract. In law, can a verbal contract supersede a written contract? I said, no, my lord. The judge then said, thank you, Mr. Pitt, you may sit down. I will reserve judgment. The same can happen in your case at any time in the magistrate's court. The magistrates will ask you questions. Some may sit and fold their arms and listen with intent. Others may fall asleep while you are arguing and not interrupt you at all. So each unto its own, they will treat it differently. Some may leave you to argue your case, the applicant first, then the respondent will answer, and then the applicant will have a reply, will give a reply. So basically, what is in your answering affidavit will be presented as the main evidence, main case. The answering affidavit will be presented by the respondent or their legal representative, and then the replying the replying argument will be presented by the applicant if needs be. But it's normally, can you see the similarities with an action? It's normally just main argument, the answer thereto, and the reply if anything has been shaken. In the action, it will be the witness that's been shaken and his testimony. In the application, it will be the legal representative that has argued the case. If he has not convinced the court will then say, at the end of the case, if the court is able to give an extempore judgment, in other words, on the spot, right after the argument of the case, the judge or the magistrate will normally say, I will give my reasons within 10 days of this judgment. If any of the parties requested, they may do so in writing. Or they will say, like they do in most cases, judgment is reserved, or the court will take time. Then you will have to wait for your judgment, and hopefully not 2 years like I have been in my one case that I'm still waiting for. So you can wait depending on where you are. But I think in my case, that magistrate has got a very difficult case to decide and doesn't know, and that's why we still don't have that judgment. Like the Aaron Motsoaledi in the extradition case of Dr. Nandipa, I have no idea what that is, Nape. Just a request for some general guidance for after class, please. How should one approach a case where it is clear from the outset what the case is not, that the case is not winnable? Does one go down fighting, or attempt to minimize the damage? Okay, Janus, from my experience, what's important is you always get your client's instructions with regards to the conduct of their matter. And you have to be truthful to your client. When you see that it's not a winnable case, you must tell your client, this is not a winnable case. And these are the reasons why. I think at this stage, we should consider settling the matter. And by minimizing the damages, or the damage, you speak to the other side and you tell them that it's give and take. We can agree on each party to pay its own costs if we settle the matter. Or we can even agree, and practitioners don't exercise these options for their clients. You say, okay, what if we say we are liable for 50% of your fees and not 100%? People don't do that. And yet it's there, it's an option. Why must you always give them 100%? Just throw them a curveball one day and say, okay, we'll pay you 60% of your fees, of your provable fees, your tax costs. They will think about it. Or you can say to them, okay, fine, this is off the record and without prejudice. And if you don't want to accept our offer, we will then run the trial, and then you run the risk of even losing your case. We're not making the offer of settlement because we don't have a winnable case. We think we think it's 50-50, and we think that we stand a good chance should we decide to argue the case. But, you know, since we are here, we might as well talk about it. And you never know, or you can even reach a compromise where you see it's not a winnable case. Let them give you something, and then you'll give them something. Then you can negotiate on the issue of fees. Janus, I don't know if that was okay. You're happy with that explanation?
Perfect, counsel. Thank you so much.
In such a case where the magistrate takes years to hand down judgment, what recourse do you have as an attorney? Sadie asks this question. We had this in the week. We spoke about this on Wednesday. We said you write a letter to that magistrate, or the clerk of court rather, asking for the judgment. If it's more than 3 months. And if the magistrate does not respond, or the clerk of court, you then escalate it to the chief magistrate. And if the chief magistrate doesn't give you any joy, you report it to the magistrates commission or the judge president of that division. What's the maximum time a judge has to give an outcome of a case? Okay, Lisa, since we are dealing with magistrates here, and the same would apply to judges, it's 3 months. Anything more than 3 months, the judge must give an explanation as to why they have not delivered that judgment. Okay, or the magistrate. Right. Now, we're done now with applications. We're going to now look at default judgment. Judgment by default, which we've done, by the way. We've dealt with default judgment on Wednesday. We're going to go with execution now. And this is not where you hang someone or you shoot someone. Sasha, that makes 2 of us. With regards to how little we were taught at university, not the first part, but involving a class. Right, now, execution is not that you can shoot your opponent or hang them. Execution refers to the judgment. What do you do with the judgment now? How do you execute that judgment? And executing a judgment means going to issuing a warrant of execution against property. If you have a judgment in your favor as the plaintiff or a defendant, and the judgment will normally say it's for payment of something, it's for eviction, it's for return of something. You then go to with that judgment, you write a letter to the person affected by it, and you say to them, on this date, we obtained judgment against you. Here is a copy of that judgment. And we want you to satisfy this judgment. We are giving you 7 days to satisfy this judgment. And if you do not satisfy this judgment within 7 days, we will send the sheriff, we will issue a warrant of execution against you to attach your property, and we will sell it on auction to the highest bidder. And if they don't act within those 7 days, you then issue a warrant of execution against property. And that warrant of execution against property is against immovable property. And that means stuff that you can move, literally. Furniture, tables and chairs. But there are certain things that you may not, that the sheriff may not attach, such as, and that those are things to live with, or to which your livelihood depends on, such as a stove. You need a stove to cook. Pots, you need pots to cook in, but obviously if you have 35 AMC pots, there's something wrong, and you can't pay your debts, there's something wrong there. Those hard pots, they can't take basic things such as pots, pans, plates, and cups, and beds, stuff that you need, basic things. They can take things such as televisions, flat screen TVs, PlayStations, couch sofas and coffee tables. Those are not basics. You can sit on the floor, especially if you don't pay your debts. And some of those things, those are the things that you can attach. Motor vehicles. But be careful when you attach a motor vehicle, make sure that it's in the name of the person and not still under finance with the bank. They can get away with it like that, because the bank will then want it back from you. So then the sheriff, after having gone to that person against whom the judgment was obtained, will give you a return of service to tell you how they executed that warrant of execution. Either they have realized sufficient property to satisfy the debt, but in most cases you find that it's not satisfactory because those things will be sold on auction, and people who go to auctions to buy secondhand goods are not going to pay top dollar for it. They're going to want it at cheap prices, and you'll find a dining room set that you paid 25,000 Rand for a year ago will be sold for 3,000 Rand to the highest bidder at an auction. So if that debt is 200,000 Rand or even 400,000 Rand, what the sheriff has attached is nowhere near that value. After they've conducted a sale in execution, and from the sale, the sheriff has realized 38,000 Rands only, there's still a big balance outstanding. And you may then issue another warrant of execution for the sheriff to go and execute at the same address of the same person to try and get the difference, the balance of what they owe you. In a nutshell, that is execution. Now, I want to touch on the part of the motor vehicle, which is under finance. ABSA have financed this motor vehicle. The sheriff, at your instruction, goes to this person's house in satisfaction of a judgment and then takes this motor vehicle, attaches and removes this vehicle from this person. The person says to the sheriff, hey, this is not my car. I still owe the bank. So ABSA owns this vehicle. ABSA owns this vehicle. I don't care. I'm the sheriff. I'm taking this car. Bye-bye. Next thing, you get the ABSA going to the sheriff's office, and they fill in an interpleader proceeding. An interpleader proceeding is the proceeding where the rightful owner of the property lays a claim to that property. And in this case, it will be for obvious reasons, because the motor vehicle itself is security for the finance arrangement between the parties, the bank and this person. And also the person, it's in the bank's interest that the motor vehicle is preserved and kept safely for the bank not to lose their right over it, right of security over the vehicle. That is what is called interpleader proceeding. And if the sheriff is not satisfied that the bank owns the vehicle, he may refer it to court. And the court will then have a hearing between the bank now, the person from whom the vehicle was taken, and the person who sent the sheriff to take the vehicle. And the three of them will make their submissions in support of their right to the property, to the vehicle in this case. And then after having heard the parties, the magistrate will then make a decision as to what is to happen to that vehicle. And most likely, if ABSA is able to prove by way of documentation that they are the rightful owners of the vehicle, the court will say the vehicle must be returned to ABSA. That was just an example of interpleader proceedings. Richard, I saw your hand was up earlier.
Yes, thanks, Counsel. I just want to know on the execution. And we know many cases the courts give a judgment to say remove the property and you obtain the judgment. What's the period that you have to effect that execution? Does it prescribe or not?
An execution?
No, like there's a judgment now for the payment of money.
Yes.
And now it's there, and you don't collect that at the magistrate's court for the sheriff now to go and attach, and it lays there and it lays there. Is a prescription on that it must be the collection must take place after the judgment, say in a year or two? Does prescription apply here?
All right. I wouldn't say prescription, but previously a summons became stale after a year, but now there's case law that says summons doesn't go stale. It remains valid until it is dismissed or withdrawn. But a warrant of execution based on a judgment, I'm not 100% sure. Those who know can jump in if they can. But after a year, you have to issue a fresh warrant of execution. You can't rely on a warrant that's a year old, that's older than a year. You have to approach the court again. You have to send a fresh warrant of execution if you want to act on a judgment that's over a year old. But a judgment doesn't prescribe. A judgment remains there until it is set aside or rescinded.
Okay, thanks, Advocate.
All right. Does anyone with experience in that field have any other views to add to that? All right, okay. Okay, let's look at here. Does the interlocutory application apply to the amicus curiae, and who makes that application? The amicus curiae application is normally an informal application. It is normally initiated by the magistrate or the judge presiding over the case, where it appears, or when it appears, that there is a need for an interested group or interested parties to be joined here as the friend of the court, such as a group that represents the rights of a specific group of people. Then the magistrate or judge may issue a notice to them. If a group, an interested group, has an interest in a particular case, they may apply to the court to become an amicus. But it's not necessarily an amicus, it'll be an interested party in this case. An amicus is normally invited by the court and doesn't need to bring an application to become an amicus curiae. Amicus curiae meaning a friend of the court, literally. We were taught theory, but PLT is about learning how to practically apply the theory. It's been a very interesting week. Thank you. Glad you find it interesting. If we're having misjoined application, can we have disjoined application? For example, disjoining a party from whom you think is not relevant in the matter, like maybe you have served minister or wrong minister. Yes, Humphrey, good question. In an application, and similarly so in an action, you may raise a special plea or a point in limine that a party has been misjoined. In other words, the wrong party has been joined. And you also have the opposite of that, which is non-joinder of a party, where, for instance, in an application for the declaration of unlawfulness or unconstitutionality of a piece of legislation, let's say it is the Local Government Municipal Structures Act. There, it is imperative that the Minister of Corporate Governance and Traditional Affairs is joined as an interested party, because that department is the custodian of everything local government. And if they are not joined, you will say there's non-joinder. You raise a special plea of non-joinder of that party. Thank you for that question. Sasha, I totally agree, Law. Focus is more on the, okay, required. Just didn't want to place the focus totally on the, okay. Can you please explain summary judgment? Also, can a party person represent themselves without the assistance of a legal rep? Okay, Ndombi Futhi. Okay, I'm going to explain summary judgment Futhi again, right? Summary judgment, as I said on one of the nights in this week, is an expedient remedy for the plaintiff in a claim, in an action for damages based on a liquid document, a liquid debt, liquidated amount, for ejectment or for delivery of a specific movable item. In those cases, after the defendant has filed a notice of intention to defend and or a plea that does not disclose a bona fide defense, the plaintiff may apply for summary judgment. If a person who represents themselves want to go that route, and if they have the legal knowledge to be able to do it, they may do so. But that, in a nutshell, is a summary judgment application. Summary judgment applications are heard in the unopposed court. As I said, it's an expedient remedy. It does not have to go to the opposed court. It is normally stood down to the end of the row, and there are only two affidavits. The affidavit in support of the summary judgment application and an opposing affidavit. Not an answering affidavit, an opposing affidavit. There's no replying affidavit, and the parties go and they argue the case on the unopposed motion court roll. The court normally also gives a judgment immediately or reserves judgment, but the court must be able to deliver judgment immediately. I've not heard of a summary judgment application that was in which judgment was reserved. Well, I've not been involved in one. What happens when the sheriff has gathered all immovable property, the auction has been held, and there is no other property that can be executed against? This is in the case where the debt is not extinguished after the writ of execution that has been executed by the sheriff. Good question, Mankope. If now, after having realized all immovable property, the sheriff is not able to satisfy the debt, the plaintiff may now go after the immovable property of the defendant or the respondent. But in order to do that, the plaintiff must bring an application for a declaration of specially execute against immovable property. And that came in because of our constitution. And there are some constitutional imperatives that have to be taken into account before you sell somebody's house in execution. And they are the right to housing, the rights of elderly and small children, elderly people and small children, the single mothers or single parents. All of those things need to be looked into before you can have a property declared specially executable, immovable property. And the person must be given an opportunity to state their case as to whether none of those conditions I've just mentioned are present in there. So the court needs to look at all of those things before it makes a decision. Do you need proof of ownership, e.g. on TV, furniture when executing if there are other people staying in the residence? Nonkanyi, so yes, preferably you would. But in most cases, things like TV and furniture, unless bought on hire purchase or what was that, credit agreements, it's difficult to prove, especially if the furniture has been around for a long time. So yeah, good luck to those who say that it's not mine. But it's good to have proof of ownership, such as receipts and agreements, credit agreements. Okay, Richard Ali. Superannuation of judgment if warrant of execution is not effected within 3 years may not be issued upon a judgment after 3 years from the day on which it was pronounced or on which the payment. Yes, thank you. That's 3 years. You've answered your own question. In the car example with reference to a warrant of execution, what happens in the car where the debtor is married in community of property and the sheriff attaches a car that belongs to the spouse of the debtor and it is paid up? Okay, what happens in the case? Oh, not the car. Sorry, I was about to say one of them gets out of the car. But if they are married in community of property, that vehicle belongs to both of them and not to one spouse only. And whatever warrant of execution is issued against the one spouse will apply to the other spouse as well in community of property. I think that question cancels itself out. Okay, in the case where a party applies to disjoin a particular party, can the party argue as to its relevancy in the case or even request a cost order in its favor for being disjoined? Okay, disjoined, non-suited is a better word. Joinder or non-joinder, misjoinder or non-joinder. I don't know which one you're referring to, misjoinder. But if a party, if the special plea still has to be argued, it's not a question of, or the point in limine, it's not a question of the person that says that the party does not need to be joined. What happens is if they agree that the party has been misjoined and should not have been a party, the party that joined that party must withdraw the proceeding against that party and must tender the wasted costs of that party having incurred to defend the action or the application or to oppose the application. I hope I've answered you, SM Katra. What if the sheriff wants to attach, for example, a fridge, but the defendant, for example, is a diabetic and medicine is stored in the fridge? Okay, a fridge is also seen as a basic, right? A fridge is also seen as a basic thing, especially in the case of a diabetic and medicine is stored in the fridge. Okay? Can the sheriff take the fridge? And how do you prove that it is necessary for your health? What remedy does the defendant have to stop the sheriff from attaching and removing the fridge? Is the fridge a necessity or not?
Good, you answered my question. Thank you.
Thank you. Is there any point in pursuing the debt when you know the debtor's assets will not cover the debt? Yes, it is. You obtain a judgment against them, and that might just get them to come and pay the debt, pay the money that they owe. Okay. And as Cora correctly says, there are provisions in Section 65 of the Magistrates Court Act to get payment out of the debtor, either in installments, or you can get a debit, an emoluments attachment order or a garnishee order against their salary if they are employed. Okay, right. Let's kick for touch now. It's Friday after all. Okay, we've dealt with those. Ejection. Ejection is eviction. And that is more tricky. I seem to be opening up cans of worms myself here. We're now on a garnishee order. What happens if the debtor has no place to go, no place to stay? How does this work then? Okay, Nimisha. If the debtor has no place to go, if that is the debtor's principal place, and I'm guessing you are talking about eviction proceedings here now, and not sale and execution of a house, because that will not stop or take away the creditor's right to recover the money from the debtor in satisfaction of the terms of a contract. The debtor can argue that I am an elderly person, or I am a single mother, I have 7 grandchildren living with me, blah, blah, blah. It doesn't take away the the creditor's rights. The creditor still has to get his rights. The court might grant judgment against those debtors or that debtor for the money value, the monetary value of the property, and will say, all right, execution will not take place immediately. But what you need to do is you need to make arrangements with the bank. It's normally the bank. You need to make arrangements with the bank as to how you're going to pay back this money. But you must understand that you cannot not pay back this money. If you can't afford to pay the bond, you have to get out of the property. And we're going to grant this application. We are giving you another chance. If you have a bona fide defense, we will listen to you. But if your only defense is that you are unemployed, you don't have money, then I'm afraid that that's not going to work. It's not a defense. Because the only defense you may have here is, I don't have money to pay. And that is not good enough. A defense may be, I am paying the bond. I'm not in arrears. I'm employed and I've been paying. Here's my proof of payment. Then in that case, by all means. And even if it's not a bank, if it gets to the stage of the sheriff now attaching the immovable property because the movable property because the immovable property is not sufficient, then still it's an issue of the debtor having to pay. And that may even encourage or motivate the debtor to want to pay the debt. Okay, you're now coming to my house, you've taken my furniture. All right, let's talk. How much can I pay you in installments? Oh, now you're talking. Of course, I'll accept installments. Litigation is not just always an off the cuff, off the menu thing. There are many dimensions to it. And that's why I said you must try to think critically at all times. Plan B, plan C. Hey, the alphabet has 26 letters, so don't stop there. Okay. Okay, now for the benefit of this person now, Motswagai, the process of a garnishee order. The garnishee order is an order that you can serve on the debtor's employee to inform and deduct a specific monthly payment from the debtor's salary. This deduction will be paid over to your and the debtor only gets part of his salary. Are you covered, Motswagai? Hopefully you are.
I am. Thanks, advocate.
Okay, good. Well, I'm going to leave some self-study to you guys. I noticed, what's his name? Quintus has been quiet yesterday and today. Is he around? Just digressing. In any event, I don't know about you guys, but I am awfully tired. Unless, of course, you want me to continue. If the person's self-employed, you can't get a debit order against them. You can't go that route. I want to ask you something. We've exceeded the program. We've exceeded the program by miles. We've completed it last night already. I said I would give you extra time today to see if I can help you into the red. Of course, subject to what you are saying. We can stop here now. Then you complete self-study 15, 16, and 17 on your own. Or I can continue and finish everything. We still have half an hour left.
We can continue.
We can continue? Can you identify yourself, please, so your colleagues will know?
Non-tobacco.
Non-tobacco wants to continue. Veronica wants to continue.
Those are all ex parte. That's
no,
an ex parte
No, we're
applications.
gonna call it a night.
No, it's not. Please, guys, please.
No.
Advocate,
Let's call it a night.
Okay, one at a time, one at a time.
Can we call it a night, Advocate? You've done a great job this week, and we appreciate everything and all the inputs that you've given us. My name is Karabo Mabilo. Thank you very much, sir.
Thank you, Karabo.
Council,
Non-tobacco is trying to be funny.
Council,
Yes.
my name is Richard Ali. I
Yes.
think all those that want to continue is all ex parte applications. The book is playing tomorrow morning, 9 o'clock.
Okay, thanks, Richard, for that.
Advocate, I second that. My name is Sasha, and I am really less for my glass of wine. So please, let's call it a night.
I didn't hear that, Sasha. Okay. All right. Everyone else, it sounds like the majority has spoken. Veronica, I'm sorry. Who else? I only seem to have heard two of you saying so. But let me take this opportunity to wish you all the best in your careers. This is just the beginning, and remember that you can do it. You can aim high. You can achieve greatness if you apply your minds, if you want to. So I want to take this opportunity to thank you and wish you all the best for the future. I hope one day we'll meet each other somewhere in a court somewhere, you never know, or maybe even with a brief from you, but you never know. And yes, thank you, all of you, and all the best for the future.
Thank you, Advocate.
Thank you so much, Advocate.
Thank you.
Advocate.
Non-tobacco, is your hand up?
Thank you so much,
Yes,
Advocate.
advocates, it is. Thank you very much for a very fruitful week and engaging week. We really appreciate it. I think we are stimulated, motivated, and I think we'll definitely work hard from here on. I think I share everyone's sentiments on that. Now, how do we reach you in the future?
How do you reach me in the future?
Yes.
Through
if we want
Zuki.
to brief you, if we want to brief you, if we want to ask questions, how do we reach you?
Go and Google me, you'll find, or
Google.
LinkedIn, you'll find me on Google.
Literally, he's there. I found him already.
I can't be accused of advertising here. I'm not allowed to advertise. But you'll find me on LinkedIn or Google, Facebook, and maybe even TikTok.
Thank you very much. We will.
All right.
Advocate.
All the best to all of you. Thank you. You've been great.
Thank you. Keep
Bye.
well.
Thank you so much. Thank you.
Thanks, Council. Have a great weekend.